Capitol Hill this morning, briefing senators on national security and operations against ISIS. That's live at 9:30 a.m. Eastern on C-SPAN 3. You can also watch online or listen on the C-SPAN radio app. In the afternoon, we're at a House hearing on alleged mismanagement in the National Park Service. That's also on C-SPAN 3, live at 1 p.m. Eastern.
IRS Commissioner John Koskinen was on Capitol Hill yesterday for a House Judiciary Committee hearing on alleged misconduct at the tax collecting agency. This was the third in a series of hearings on Koskinen's response to congressional subpoenas for emails from the agency. This is about 3.5 hours.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess of the committee at any time. We welcome everyone to this morning's hearing on the impeachment articles referred on John Koskinen, Part 3, and I'll begin by recognizing myself for an opening statement. The Constitution sets forth a system of checks and balances which grants each branch of government tools to help ensure that no one branch of government attains too much power. The legislative branch's tools include the power to write the laws, the power of the purse, the impeachment power, the power to censure, among others. These tools empower Congress to exert oversight over the executive and judicial branches, including rooting out corruption, fraud, and abuse by government officials and taking further disciplinary action on behalf of the American people when warranted. The duty to serve as a check on the other branches, including against corruption and abuse, is a solemn one, and Congress does not and must not take this responsibility lightly. That is why this committee has scheduled this hearing today. In 2013, the American people first learned that their own government had been singling out conservative groups for heightened review by the IRS as they applied for tax-exempt status. This IRS targeting scandal was nothing short of shocking. It was a political plan to silence the voices of groups representing millions of Americans. Conservative groups across the nation were impacted by this targeting, resulting in lengthy paperwork requirements, overly burdensome information requests, and long, unwanted delays in their applications. In the wake of this scandal, then IRS official Lois Lerner stepped down from her position, but questions remain about the scope of the abuses by the IRS. The allegations of misconduct against Mr. Koskinen are serious and include the following. On his watch, volumes of information crucial to the investigation into the IRS targeting scandal were destroyed. Before the tapes were destroyed, congressional demands, including subpoenas for information about the IRS targeting scandal, went unanswered and were not complied with. Mr. Koskinen provided misleading testimony before the House Oversight and Government Reform Committee concerning IRS efforts to provide information to Congress. These are very serious allegations of misconduct, and this committee has taken these allegations seriously. Over the past several months, this committee has meticulously pored through thousands of pages of information produced by the investigation into this matter. On May 24, this committee held a hearing at which the House Oversight and Government Reform Committee formally presented its findings and evidence to the members of this committee. Then on June 22, this committee held a second hearing to allow outside experts to assess and comment on the evidence presented to the committee at its May 24, 2016 hearing and the options for a congressional response. Today we hold a third hearing and hear from Mr. Koskinen himself. I look forward to hearing from Mr. Koskinen today. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members, and I want to thank first Commissioner Koskinen for joining us today on short notice and under these unusual circumstances. Last week, a handful of my colleagues attempted to force a vote on your impeachment, and when it appeared that they would fall short of the necessary votes, that effort was abandoned, and this hearing was scheduled instead. I hope that my colleagues now see what I see when I look back at the history of impeachment in the House of Representatives, which we all have an obligation to do. No matter how we feel about a particular official, no matter what we think of his or her agency, successful impeachments are bipartisan efforts, and partisan attacks cloaked in the impeachment process are doomed from the start. Mr. Chairman, the effort to impeach Commissioner Koskinen is destined to fail on both the merits and as a matter of process. And if they somehow force this measure to the floor again, I fear it will set a terrible precedent. On the merits, the Commissioner's critics simply have not proved their case. In fact, every other investigation to have examined these facts have refuted the charges against Commissioner Koskinen. The Senate Finance Committee, in a report that serves as the only bipartisan account of the matter, found no evidence that the Commissioner had intent to mislead Congress at any time. The Department of Justice found, and I quote, found no evidence that any IRS official acted based on political, discriminatory, corrupt, or other inappropriate motives, end quotation. And, quote again, no evidence that any official attempted to obstruct justice, end quotation. The Treasury Inspector General for Tax Administration again found no evidence to show that IRS employees had been directed to destroy or hide information from Congress. Despite these findings, some members continue to insist that the Commissioner ordered, quote, ordered 24,000 emails erased before Congress could review them, end quotation marks. Citing zero evidence to back the claim, independent fact checkers rated this statement as categorically false. There's simply no evidence that the Commissioner has acted with intentional bad faith in his leadership of the Internal Revenue Service. But even if there were some evidence of wrongdoing, the push to impeach the Commissioner on the House floor without even basic due process in the committee is wildly misguided. According to parliamentarians of the House, past and present, the impeachment process does not begin until the House actually votes to authorize this committee to investigate the charges. In other words, this is not an impeachment hearing. Merely including the word impeachment in the title doesn't do the job at all. And at an actual impeachment hearing, the Commissioner would be represented by counsel, and he'd have the right to present evidence, the right to question the evidence presented against him. In this case, by contrast, the Commissioner has been denied access to the transcripts of interviews conducted by the House Oversight Committee, even though we are told that those transcripts were key in forming the charges against him. Many members of this committee are in the same position, I might add. I'm not alone in being skeptical of short process or in noting the importance of a full and independent investigation by this committee. In 2006, Mr. Sensenbrenner, the gentleman from Wisconsin, argued, and I quote, "Only after the House Judiciary Committee has conducted a fair, thorough, and detailed investigation will committee members be able to consider whether articles of impeachment might be warranted," end quotation. In 2010, Mr. Chairman, you expressed confidence in our impeachment task force because it had conducted an exhaustive investigation. That investigation included, in your words, quote, reviewing the records of past proceedings, rooting out new evidence that was never considered in previous investigations, conducting numerous interviews and depositions with first-hand witnesses, and conducting hearings to take the testimony of first-hand witnesses and scholars, in quotation marks. All of that process is missing here. Yes, we have it within our power to skip these steps, but what kind of precedents does that set? Never in the history of this body have we impeached a government official without first proving that he has acted in deliberate bad faith. Never in modern practice have we declined to provide the accused with the most basic due process, the right to counsel, the right to present evidence, and the right to question the evidence against him. If the commissioner's critics have their way, I fear we will have a new rule going forward. The House may impeach any government official for any reason, without supplying evidence of deliberate wrongdoing, without an independent investigation, and without regard to basic fairness towards the accused. Forcing a vote in this manner will certainly not result in the removal of the commissioner. Even if his critics succeed here, senators of both parties have already stated their intent to bury the matter. And in the process, I fear, we will have stripped our responsibilities of their weight and dignity and turned impeachment from a constitutional check of last resort into a tool of political convenience. And I cannot accept that, and none of us should. Commissioner Koskinen, thank you again for your willingness to be here today. Stick to the law and the facts, and you'll be fine. I yield back, Mr. Chairman, and I thank you.
Chair thanks the gentleman. Without objection, all other members' opening statements will be made a part of the record. We welcome our distinguished witness, and Commissioner, if you would please rise, I'll begin by swearing you in. You swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Let the record show that the witness answered in the affirmative. Commissioner John Koskinen was sworn in as the 48th IRS Commissioner on December 23, 2013. Prior to his appointment, Mr. Koskinen served as the non-executive chairman of Freddie Mac from 2008 to 2012, acting chief executive officer in 2009. Previously, Mr. Koskinen served as president of the U.S. Soccer Foundation, deputy mayor and city administrator of Washington, D.C., assistant to the president and chair of the President's Council on Year 2000 Conversion, and deputy director of the Office for the Management at the Office of Management and Budget. He holds a law degree from Yale University of Law and a bachelor's degree from Duke University. Mr. Koskinen, you are welcome. Your entire testimony will be made a part of the record, and we ask that you summarize your testimony in 5 minutes. Your written statement, as I said, will be made a part of the record, and you see a timing light on the table. Please help us. We have a lot of members with a lot of questions to ask.
Thank you. Good morning, Chairman Goodlatte, Ranking Member Conyers, members of the committee. Thank you for the opportunity to answer questions here today. I understand the extraordinary responsibilities entrusted to this committee. I appreciate both your willingness to hear from me and the serious and fair-minded approach you have taken on the discharge. All right, is that counted as my time? All right. Thanks. I'll do my best today to answer your questions, and I'm committed to full cooperation. I recognize the obligation all public servants share to be responsive to Congress to the best of our abilities. That means listening and responding to feedback and criticism, acknowledging mistakes, and working diligently to improve. Let me note at the outset how much I deeply regret our inability to bring the C-4 issue to a close in a way that satisfies all Americans and members of Congress. I understand the level of suspicion and distrust caused by the IRS's failure to properly handle applications for social welfare status based solely on the names of the organization. I took this job in large part to help restore confidence in the IRS and to ensure that the agency never returned to the unacceptable practices that had occurred before I arrived. I believe we've made real progress during my tenure in ending the practices that gave rise to the concerns, addressing operational weaknesses, creating a culture of risk management, and working to reassure taxpayers that our tax system treats taxpayers fairly. The tax system only works if taxpayers are confident that the IRS will treat them fairly and that it doesn't make any difference who they are, what organization or political party they belong to, or whom they voted for in the last election. This is an important principle to us at the IRS, and no one, in addition, should have to wait years for an answer to a question or a request for a determination of any kind. Congress also has a right to expect that reforms to restore the public's trust in a nonpartisan and effective IRS will be implemented fully. I've devoted my energies as Commissioner to that goal, and the Inspector General has acknowledged that real progress has been made in implementing all of his recommendations. For instance, the IRS eliminated long ago the use of the Beyond the Lookout, or BOLO lists as they're known, that had resulted in the improper scrutiny of a number of applicants as described in TIGTA's May 2013 report. The IRS has also offered an expedited approval process for organizations that experience delays in the processing of their applications for 501c4 status. Continuing our efforts to restore public confidence in the IRS will remain my top priority every day that I'm fortunate enough to continue to serve. I also understand there are significant remaining questions on the minds of some members about the IRS response to congressional inquiries on my watch. I stand ready to answer these questions today. I responded honestly and in good faith as events unfolded, particularly in response to the discovery that Lois Lerner's hard drive had crashed in 2011. From the start, I directed IRS staff to cooperate fully with Congress and to recover lost information wherever possible, and I testified to the best of my knowledge. But the truth is, we did not succeed in preserving all of the information requested, and some of my testimony later proved mistaken. I regret both of those failings. I can also tell you that, with the benefit of hindsight, even closer communication with Congress would have been advisable. But my commitment is, and always has been, to tell you and all committees of the Congress the truth and to address issues head-on. I accept that it is up to you to judge my overall record, but I believe that impeachment would be improper. It would create disincentives for many good people to serve, and it would slow the pace of reform and progress at the IRS. Again, I appreciate the opportunity to be here and look forward to answering your questions.
Thank you, Commissioner. We will now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself. The report of investigation by the Treasury Inspector General for Tax Administration, or TIGTA, concludes in its 2015 report regarding congressional requests for emails that, and I quote, "The investigation revealed that the IRS did not put forth an effort to uncover additional responsive emails. None of the IRS employees involved had been asked prior to the June 30, 2014 request from TIGTA to find any backup tapes or the server hard drives associated with the NCFB Exchange 2003 server, which would have contained responsive learner emails. The investigation determined that if the IRS would have conducted a search for the existence of backup tapes, they would have found the necessary backup tapes that contained learners' missing emails prior to when those tapes were degaussed in March 2014, unquote. Mr. Koskinen, is there anything inaccurate in that finding of the Treasury Inspector General for Tax Administration? And if so, what is inaccurate from it, about it?
No, it's nothing inaccurate in that. I'd be happy to explain to you my understanding of how that happened, but the report is accurate.
Do you believe that it was the duty of the IRS Commissioner to, as the Treasury Inspector General for Tax Administration stated, put forth an effort to uncover additional responsive emails to Congress's inquiries? Yes or no?
Yes.
The report of investigation by the Treasury Inspector General for Tax Administration also concluded in its 2015 report as follows, and I quote, "The investigation revealed that the backup tapes were destroyed as a result of IRS management failing to ensure that a May 22, 2013 email directive from IRS Chief Technology Officer concerning the preservation of electronic email media was fully understood and followed by all of the IRS employees responsible for handling and disposing of email backup media." Is there anything inaccurate in that finding of the Treasury Inspector General for Tax Administration?
No.
Do you believe that it was the duty of the IRS Commissioner to, as the Treasury Inspector General for Tax Administration stated, to ensure that a May 22, 2013 email directive from IRS Technology Officer concerning the preservation of electronic email media was fully understood and followed by all of the IRS employees responsible for handling and disposing of email backup media? And I'd appreciate a yes or no response to that.
Yes, to the extent the IRS Commissioner has control over that.
The official IRS website, in its section describing you, Commissioner John Koskinen, states, "Mr. Koskinen manages an agency of about 90,000 employees and a budget of approximately $10.9 billion. You are the top manager at the IRS. So when the Treasury Inspector General for Tax Administration concluded that the IRS did not put forth an effort to uncover additional responsive emails and that the backup tapes were destroyed as a result of IRS management failing, the Inspector General was referring to you, the manager of the IRS. Is that correct?"
As the leader of the organization, I am responsible for the management of it. There are a lot of managers there, but ultimately any CEO, any director of the organization is responsible for its operations.
So after you received the congressional subpoena, which affirmatively required that you protect all emails related to this subject, what affirmative steps did you take personally to ensure all responsive documents were preserved?
I met with senior executives and was assured that an appropriate document retention order had been put out the prior year. The woman acting as my counsel at the time sent a follow-up memo in February to the IT department to remind them that they ensure that all of the available information be preserved, and I was assured that that was being done.
Did you send anyone to different locations where emails are degaussed or destroyed, if you will, and instruct them not to destroy any emails without first going through the persons responsible for your responsibility to respond to this subpoena and say, make sure that no emails are destroyed without first verifying that they're not related to this congressional subpoena?
I did not personally do that. I was assured that managers understood the impact of the document retention request or order in 2013 before I arrived, and the follow-up in February 2014, I was assured would make it clear to employees and managers everywhere to preserve documents. We were at that point 8 months into a massive document search, so it did not, it seemed to me everybody would understand the goal and the instruction to people was to produce all of the information as quickly as we could wherever it was.
But apparently that message didn't get to the people who actually do the work of destroying emails.
It apparently got to everyone but 2 employees on the midnight shift in Martinsburg. And at the time that was revealed, which was a year after the hearings in 2014, I said that that was a mistake, it shouldn't have happened, and I took responsibility for it.
My time's expired. Thank you. The chair recognizes the gentleman from Michigan for his questions.
Thank you, Chairman Goodlatte, and welcome again to the committee, sir. Yesterday, the chairman and I received a letter from our colleagues and some 32 signatures, and I ask, Mr. Chairman, that this letter be made a part of the record.
Without objection, it will be made a part of the record.
Commissioner Koskinen, this letter cites the example of one of our colleagues who claims the head of the IRS ordered 24,000 emails erased before Congress could review them, end quotation. Commissioner, did you order the destruction of 24,000 emails in an attempt to obstruct congressional investigators?
I did not.
Of course you didn't. According to PolitiFact, there is no zero evidence to support this claim. The letter also cites to an exchange of letters which J. Russell George, the Treasury Inspector General for Tax Administration. Mr. Chairman, I ask that this letter be made a part of the record as well.
Without objection, it will be made a part of the record.
Thank you. In 2015, the Inspector General released a report that concluded no evidence was uncovered that any IRS employees had been directed to destroy or hide information from the Congress. This same conclusion was independently reached by the Senate Finance Committee and the Department of Justice. Last week, my colleagues wrote to the Inspector General to ask him if he had obtained any evidence whatsoever over the past year to cause his office to change its conclusion. He responded within a day, and the answer was no. Commissioner Koskinen, to your knowledge, have any of the underlying facts changed since the Senate Finance Committee, the Department of Justice, and the Treasury Inspector General concluded that there is no evidence of your intent to mislead Congress or obstruct the investigation?
No.
I spoke earlier about the precedent of the House, which has always provided some basic due process to an accused official. For example, in 2010, we allowed Judge Porteous to submit evidence, call witness, and cross-examine others. In 1996, we allowed counsel for President Clinton to do the same. In 1874, this committee allowed Secretary of War William Belknap the opportunity to explain, present witnesses, and cross-examine witnesses. But here, in 2016, I understand that you have not been allowed to review the evidence against you. The Oversight Committee conducted over 50 transcribed interviews and claims that those interviews were key to forming the charges against you. Mr. Commissioner, have you asked to review these transcripts?
We have.
Have you been given an opportunity to review them?
No.
Do you believe they might include evidence that clears you of any of these charges?
I do. If there were any evidence there that I'd actually indicated or told anyone to impede the operations of the Congress, destroy or mislead the Congress, I assume someone would have already quoted it. So I assume that those 50 depositions would support the fact that I did nothing to impede the operation of the Congress. I gave no instructions to anyone to do anything other than fully cooperate with the requests of the Congress.
I thank you, sir, for your testimony, and Mr. Chairman, I yield back.
Chair, thank